maybe. Thanks everyone for joining us. I'm Jenny Laurie from Housing Court Answers. We're going to be joined today by Judge Schneider, who will give us what we thought originally maybe a year ago was 1 or 2 updates on COVID in the housing courts, and now is just turned into, I don't know how many times Judge Schneider's been with us, but it's great to have her, but it's not great to keep having to do these updates. I just was briefly on the OTDA update just about an hour ago. And it sounds like they're finally sort of working out some of the kinks and getting a lot of the money out the door for the Hra application process. So that's really great news. For those of you who don't know Judge Schneider, she is the citywide supervising judge of the New York City housing courts. And she'll give us an update on what's going on in the housing courts. Things have changed a lot recently. As everyone knows, the moratorium has changed, been reenacted basically. And of course, the housing court procedures have changed as well. And Judge Schneider will talk to us about that, and then we'll take questions. We have until 3. So if you could put your questions in the chat, and we'll try to read those out in the order that they come in. So once again, thanks for joining us, and thank you, Judge Schneider, and I'll hand it over to you.
Great. Thanks everybody for coming and for taking an interest. One of the interesting things about the pandemic period is that the housing court, which was always the poor stepchild of the court system, the forgotten corner, the hidden embarrassment, whatever it was, is now on the front pages of everything all the time, and the only thing anybody ever wants to talk about. That has its pluses and minuses, but if you've been around as long as I have, or Mary Zulak has, it is an odd place to be. In terms of where we are now, I have to say a couple of things preliminarily. The first is that in the last week in August, I recorded a session for a judicial seminar on where housing court was now in the pandemic period. I actually recorded it not in the last week, but in the second to last week. And then we had to shred it, because by the time it was going to be played, it wasn't true anymore because the Supreme Court struck down SEPT. And so now I'm supposed to record again on September 23rd. And I'm a little bit afraid that the same thing will happen again, because I gather that RSA is now back in the Second Circuit, and maybe they will do what they did before and go straight to the Supreme Court after the Second Circuit. I don't know. But in terms of where we are now, I'm going to summarize just very briefly, and then tell you about one new thing that's happening. The legislature extended the SEPT moratorium to January the 15th. They did that last week. They changed the law in certain respects. They created a process that a landlord can use to challenge a hardship declaration. That process is set up in a way that says that the hardship declaration establishes what is called a rebuttable presumption of hardship, which means unless the landlord comes forward with some showing that there isn't a hardship, there's a hardship. The petitioner's side complains that this doesn't really address what the Supreme Court was concerned about, because it doesn't make the tenant prove hardship in the first instance. I don't know how all of that is going to come out. In the same package, the legislature also created a nuisance exception to the ERAP stay. That nuisance exception looks just like the nuisance exception to SEFPA, and it didn't come as a tremendous surprise to us. And it does clarify, I think, that they intended the well, that they intended the ERAP stay to apply to other kinds of holdovers, which had been a subject of some discussion. One new thing that we are starting to do, there is going to be a DRP issued on it probably by the end of the day today. We are going to start next week placing new cases on the calendar. In other words, up to now, we've been working from oldest case. We've been working forward from the oldest cases, trying to get cases on a calendar and assign counsel. We're going to try to create a current situation to keep up with current while we continue to maintain effort on those old cases. So starting on Monday, if a tenant comes in to answer a case on Monday, they're going to be given an appearance in what we're calling an intake part. That intake part will start calendars on September the 21st. The only purpose of the intake part is to assign counsel. So the intake part is preferably virtual. The tenant will receive information right away on how to connect virtually, but will also have the option of coming in person. The legal services providers will appear virtually. Counsel will be assigned, and then the case will be moved to a resolution part. We're not taking any dismissals or defaults in that intake part. It is literally solely for assignment of counsel and then to move it to a resolution part. The first appearance in the resolution part is going to be presumptively in person. What we're hoping is that the calendars in the resolution part that are in person are going to be very, very small. Our supervising judges have walked around and figured out how many people can be socially distanced in each courtroom. We will not put on any more cases than we think will fit in the courtroom. Cases will be put on in 1 hour time slots, and just a few of them. And the judges and court attorneys will be working on a virtual calendar and an in-person calendar at the same time. Judges do have the option of accepting adjournments of those cases in whatever way the judge chooses to manage the calendar. So that we're not forcing anything. Judges control their own calendars. But what we're hoping is that instead of every day adding more cases to the backlog, we're hoping to start hearing new cases now while we continue to address the backlogs. And in terms of backlogs, I just want to say that in Manhattan and Queens, we are pretty much through the pre-COVID cases. The pre-COVID cases have all been put on the calendar, counsel assigned, and some of them are still pending, some of them have been resolved, but we still have a few Harlem cases to get on, but otherwise Manhattan and Queens are pretty well caught up on pre-COVID cases. The same is not true of Bronx and Brooklyn. Bronx and Brooklyn, we're still trying to catch up on those cases. But in Manhattan and Queens, we'll soon be moving into the same kind of process for cases that were filed when we started to take new cases last year in June, cases that were filed from then until now. We'll start to try to get those on the calendars. We did some non-payment cases from that bucket of cases in the cap parts through the spring and summer, but we mostly have not touched the non-nuisance holdovers from that bunch of cases. We are experiencing some confusion about the cases with hardship declarations. We have about 40,000 cases in which there are hardship declarations. Between the time that the Supreme Court issued their injunction and the time that the legislature passed the new law on September 2nd, most of us took the cases that had been taken off the calendars because of the hardship declarations and put them back on. We're now in the process of taking them off again. And that is going to be something of a process. I would suggest to practitioners that might be in this meeting that if you think a case is on the calendar and shouldn't be, you should contact the chambers of the judge who has the case and say, I think this needs to come back off again because either it has a Hra application or it has a hardship declaration. The process of on, off has been confusing for us, or not confusing, but trying, let me put it that way. I think that's all I really want to address to begin. I'd like to spend as much time as I can answering questions because I know there are lots and lots of them.
Great, thank you, Judge Schneider. So my sound is okay. If folks have questions, can you put them into the chat? I don't see, I know some people had some questions before, so people emailed or sent us questions before, so I'll just start with those. One of the questions that has come up is what's going to happen to tenants who either don't file answers or don't show up for their that first sort of virtual appearance where they would be assigned counsel.
So let me address the tenants that don't file answers to begin with. Tenants who don't file answers, we're still in the new statute that was passed last week, which doesn't seem to have a nickname, so I don't know what to call it. It puts us back in the situation where a petitioner has to make a motion for a default judgment. Mostly we're finding that when we send the respondent a notice on those motions and invite them to appear, mostly we're getting people to appear. Those motions are being made in the HMP parts. The case is put on twice in the HMP part. If the tenant doesn't appear the first time, we collect as much contact information as we can. Landlords frequently share with us the contact information that they have. If the tenant doesn't appear a second time in the HMP part, we will shift that case to a resolution part and it may be decided on default. If the tenant does appear in the HMP part, counsel is assigned. And in general, there'll be an answer and the case will come out of that default category. The other good news about that category of defaults is that we now have access to the OTDA data for who has filed an ERAP application. So if I was really worried that there could be tenants out there who had filed an ERAP application and would say, you know, I heard on the news that if I filed this, my eviction was stopped. So why do I need to go to court? And I wanted to make sure that we had a way of knowing whether there was an ERAP stay in a situation in which we didn't hear from the tenant. And we now think that we do have the ability to do that. Some of the details of how that access works are not worked out, but I think they will be within a couple of days. The technology people on both ends are working on that. In terms of the new intake part, if the tenant does not appear in the intake part, the case will move to the resolution part, and it will be up to the resolution judge to do that process of reaching out and getting contact information and trying to get the tenant in. But that may also become a place where defaults do get taken and where we need to check and see if we have other information or notice of an ERAP application. In those cases. In any case, the details of what a default judgment looks like and what a warrant has to recite in terms of service with a hardship declaration and those things is all still in effect in the new law. And we are prepared to receive orders to show cause from tenants, to put them on a calendar, whether I think we may well, when we start to get orders to show cause, we may well put them we will put them on one of the calendars where council gets assigned.
Great, thank you. I'll just read down through the questions that are in the chat now. If we have, and some of them are from attorneys who practice, and some of them are from people with more of a distance from cases.
All right, I will try to make my answers not designed for lawyers only. I know I did a bit of law talk in my initial presentation, for which I apologize.
Thanks. If we have existing Teams invites for upcoming court dates, can we continue to rely on appearing virtually?
If you have a Teams invite for a case, you can assume that that case is going to be heard virtually. We are not converting virtual appearances to in-person. What we're trying to do is to see whether our capacity improves if we combine some in-person with the existing virtual, and it's our intention to continue pursuing the old cases in the virtual way.
Here's a question. I'm not sure exactly what this means, but what about holdover cases in Brooklyn where the tenant filed a hardship declaration? I'm not sure how that's different from any other borough, but
when we receive a hardship declaration, let's say we receive a hardship declaration from a tenant in a case that we haven't put on a calendar and that we haven't assigned counsel for. Those cases are put on an administrative calendar. They're not put anywhere. They're put in a place that's designed to hold them for as long as the hardship declaration is in effect. We took some of those cases out and put them back on calendars after the Supreme Court order. All of them have been taken off again. So in terms of the cases that were on administrative calendars, those should go back on an administrative, those will be back on our administrative calendars. A hardship declaration, unless we get a motion from a landlord asking to challenge the hardship declaration, in which case we'll put that if the tenant doesn't have counsel, we'll put that motion on the HMP calendar, give the tenant notice, assign counsel, and move forward that way.
What about an ERAP case? I guess a tenant with a case who filed an ERAP application, but the landlord wouldn't participate. What will happen with those?
The filing of an application triggers the ERAP stay. The landlord's failure to cooperate with the ERAP application process doesn't change the stay, and the stay is until OTDA either denies or grants it says denies until OTDA denies the application. So I don't see how the landlord not cooperating in the application changes the ERAP stay.
If an owner challenges a hardship declaration in which the tenant checked B for disability or physical hardship, is there guidance as to health privacy with respect to how the challenge hearing will be conducted?
There isn't any guidance at all. We haven't done any of these yet. And one of the things I want to emphasize is I realized in a couple of things I've said in answer to the last couple of questions, I have given my view of how a particular statute applies. And I want everybody to understand that individual judges are allowed to interpret a law differently from the way I interpret it. So I get to give administrative guidance in terms of what calendar something will be placed on, how many times it'll be adjourned, that sort of thing, but not to tell a judge how to apply a particular law. So I want to make sure that that's clear. Come back to the question for me, Jenny, for a minute.
So do you want me to
Yeah,
read
if
the
you would
question
repeat it,
again?
yeah.
Yeah. So if an owner challenges the hardship declaration in which the tenant checked B for disability or physical hardship, is there guidance as to health privacy with respect to how the challenge hearing will be conducted?
I think that we have to assume that if a tenant is seeking a hardship stay based on disability, and if the landlord comes forward with something, the landlord has to come forward first. If the landlord comes forward with something that challenges the tenant's entitlement to that, the tenant is going to have to come forward with their evidence. And you're allowed to keep things private, but a court isn't going to be able to rely on stuff that's kept private. And again, and this is why I wound up going into individual judges. Because we have no experience with this, literally no experience at all with this yet, I'm not exactly sure how courts are going to conduct these hearings. I think we're going to have to kind of try things out and see how they go.
Right, now we're going to telescope out a little bit. What does the acronym CEFPA stand for? I heard this regarding the nuisance exception to the ERAP stay.
CEFPA stands for the COVID-19 Emergency Eviction and Foreclosure Prevention Act. It's the initials that make up that nickname for the moratorium law that became effective on December 28th of last year, and was in effect until the Supreme Court enjoined it in August. And then it expired by its own terms on August 31st, and it was replaced by a new law that the governor signed on September 2nd.
Thank you. In Staten Island, the ERAP program is being slowly stood up. Do you have advice for tenants and landlords on Staten Island?
There shouldn't be different rules for ERAP in Staten Island than anywhere else. I think that the ERAP program everywhere was very slow getting started. Through June and July and a significant part of August, there didn't seem to be a whole lot of activity going on. At this point, there have been many millions of dollars in grants issued under ERAP, and more millions that are, I forget what the word is used, but that are committed, but waiting for landlord information for direct deposit and that sort of thing. And I think it's close to $1 billion that's been fully committed from ERAP. It's not a separate program in Staten Island from anywhere else. New York City is not different from most of the upstate counties either. It's a statewide program. There are a couple of counties upstate that chose to run their own programs, but for the most part, it's a statewide program.
Will there be call-in capacity for tenants who don't have video conferencing ability but don't feel safe coming in person?
Yes, every court part in the housing court has call-in capability for their video conferences. The only appearances now that are presumptively in person, there aren't any right now, but starting September 21st, there will be a first time on and a resolution part for new cases that is presumptively in person. It is anticipated that the vast majority of those cases will be two-attorney cases, so that the tenant doesn't need to come in if they don't want to. But again, there is call-in capacity in every courtroom, so a judge can make provision for that. And tenants will have the opportunity to ask for it. We'll make the information available in terms of how you can ask for it.
I'm going to rephrase this next question a little bit. Can you appoint a GAL to locate a tenant, thinking that some tenants who don't respond, who default, might be homebound or have a mental illness or be temporarily hospitalized?
We are very much aware that there are lots and lots of tenants who are not still in the same place that they were before the pandemic. And we can't use the GAL process for that, because in order to appoint a GAL, you have to make certain findings about the tenant. So a GAL isn't an investigator for the judge, so that won't work. We are using a variety of other tools. Sometimes we've used a referral to APS for that purpose, because the APS social workers do make home visits and do make reports back to us. So we've often been able to get information that way. And we have found that the lawyers representing landlords have done their best to collect any contact information or additional information that they may be able to get from their clients, either because the tenant shared with the landlord an email address or a telephone number, or because the superintendent knows from the building what's going on with the tenant. So we have been pretty fortunate in terms of being able to collect information there. There are situations, however, in which we just haven't been able to get any good information, and we're without it. So it's not, the tools that we have are not perfect by any means.
And then here we are back to, I guess, to a legal service provider. Will the intake part cover multiple boroughs' jurisdictions?
Every borough has its own intake part, except Staten Island, which of course has one part for everything.
And then there's been a couple of questions about pre-COVID cases. Where are there different rules for those cases vis-a-vis the hardship or ERAP? So if a case was filed before March of 2020, okay.
Nope, not at all.
This is a question that's come up a couple of times. What measures, protocols are in place for litigants that are scheduled for a first appearance in person but are having flu-like symptoms, recently tested positive, or et cetera? And so I assume the question is, and they won't be allowed, obviously they won't be allowed.
They will not be allowed to the courthouse. One thing I would encourage everybody to do is to look on the court website at what our current protocols are for health and safety in the courthouse. Because they've changed and changed back again a couple of times. We are doing temperature checks. We have questions that we ask at the door. If somebody has a temperature or is experiencing other symptoms, they will not be allowed in. The officer who speaks with them at the door will inquire their purpose in coming to court, and will contact the court part, or they'll be asked to step outside and make a phone call, and given contact information to make that call. This is something that we've been doing all along, and we're pretty accustomed to making those arrangements for people when they come in. People will not be allowed to enter the courthouse unless they are masked. And masking is required for as long as any member of the public, any lawyer, anybody vaccinated or not is in the courthouse. They will be required to be masked.
And this is a follow-up question. What are the courthouse's contact tracing and notification procedures? So I assume that's if someone was in the court on a Tuesday and someone tested positive, is the court going to notify everyone in some way who was there on Tuesday?
If we are, again, this is on the website, but if we are notified of a positive test, we track where the person with the positive test was during the relevant period prior to the positive test, and we do contact tracing for those.
This is a question that comes out of the meeting with Judge Breyer yesterday.
I wasn't at that meeting, so you may have me at a disadvantage, but I'll try to answer the question.
Okay. We asked if there will be limits on occupancy, and we were told there is no decision on this yet. I have many staff who do not want to go to the court if the court is not sanitizing and limiting occupancy. Will we receive word on occupancy limits and sanitizing of the courthouse soon?
Okay, so let me address occupancy limits first. We don't have like a number, only this number of people can come into the courthouse. Courthouses have to be open and available to people to come into, and all of our courthouses are open and fully staffed and available for people. In terms of scheduling these in-person appearances, which I'm assuming is what's causing the question, we're doing a number of things to avoid having too many people in the courthouse. Anybody that was ever in housing court pre-COVID imagines that when we start doing in person, we're all of a sudden going to have crowded hallways again. That is not going to happen. We are putting on a very limited number of cases in any given courtroom. In addition, we are not creating in-person calendars on any courtrooms that are next to one another, or in the same general area of the courthouse. If in the Bronx, for example, each floor has 2 courtrooms in the front and 2 courtrooms in the back. On any given day, only one of the front courtrooms will have a calendar, and only one of the back courtrooms will have a calendar. In Manhattan, no courtrooms that are on the same hall will have in-person calendars at the same time. Brooklyn, as you can imagine, those of you who are familiar with Brooklyn, has extra challenges. And we're being very, very careful in terms of what we put on in Brooklyn in areas that are near one another in the courthouse. And we're aware that there's only one bank of elevators and that not very many people can fit safely into any given elevator at the same time. Our instructions for these calendars is to observe social distancing strictly, and we are going to do that. We will not be permitting any congregating in the hallways, for example. You can't have an old style hallway housing court conference and observe social distancing. You can't do it, and so we won't be doing it. So although I can't tell you we have a specific number of people that can go into any particular courthouse, I can tell you that we are very strictly limiting where we're proposing to send people. Jenny, I have a feeling there was another piece of that question that I'm forgetting. I'm sorry.
Well, occupancy limits and then the sanitizing is the other question. So.
Our courtrooms are fully wiped down every day. We have plexiglass in many courtrooms. We do not have plexiglass in all courtrooms. I think you'll find if you read up on it that the current science about how the virus moves says that plexiglass is not any help. And so OCA is not doing any more plexiglass. But in terms of our cleaning protocols, they are very, very strict, and every courtroom will be cleaned constantly.
If there's a non-payment case pre-COVID and the client was able to pay their rental arrears with ERAP, how soon will the case be put on the calendar to discontinue the case?
There are a couple of different pieces to an answer to that. The first is that we have an administrative order that requires a landlord to report to the court when the landlord receives ERAP money. That enables us, even if we don't receive a formal discontinuance, to know that money has been paid on that case. We anticipate that where both sides have lawyers, if there's an ERAP payment that resolves the case, we'll receive a stipulation of discontinuance. We have told the parties that if a landlord believes that an ERAP payment does not resolve the case and that there are more issues, the landlord can make a motion to put the case back on. We have also said that if there are cases that are still on our ERAP calendars when the ERAP process closes, we will be creating calendars of those cases so that we can notify people that we're putting the case back on so that we're sure we know whether the case is over and can be dismissed.
This is slightly related. If a new case is given an intake date, will the tenant be able to inform the court of the ERAP application at that time? Okay.
Absolutely.
Sorry, I have a super long question here that I don't quite understand. I'm going to skip it down. ERAP makes an exemption for small landlords with 4-family or less buildings of 4 families or less to be able to evict if they want to move back into their home. Will the court facilitate that if there's no COVID-related hardship?
If a landlord seeks to have the case that it recognize that the case falls into that exception, we will look into it and apply it.
Will people who enter the court be required to show proof of vaccination? I think you answered that, but go ahead.
Yeah, no, there's no, the court employees have vaccine mandates. Members of the public who attend court do not.
Let's see, sorry. There's a few questions that are just repeating what's already been answered, so I'm trying to scroll down.
Okay.
Will attorneys have the option to appear virtually for the cases in the resolution part?
That first court appearance on the new cases is presumptively in person. The resolution judges are in control of their own calendars. I don't know whether particular resolution judges will consider converting a case to virtual or adjourning it. I want to emphasize, by the way, that this is one in-person appearance per case. In other words, the anticipation is that the first appearance in the resolution part is in person. After that, it's up to the judge how the judge wants to manage it.
So we're getting close to the end here. There have been issues citywide with mask enforcement in the courthouses. How will masking be enforced? And another part of this question is, have the ventilation systems in every courtroom been tested to make sure they are adequate?
We had, at the time when we first had court employees coming back to the courthouses, we had very extensive studies of our ventilation systems and our the filters in the ventilation systems. And you can imagine that our employee unions and our judges were extremely concerned about these, because we spend all workday, every workday in the courthouses. Judges have been working in the courthouses full time since last year in June. And all of the rest of our employees have been working full time in our courthouses since May of this year. We worked with experts, an epidemiologist and HVAC expertise to make sure that our ventilation systems were all appropriately functioning.
So there's two related questions. One is, can parties stipulate for every appearance after intake to continue virtually, or is this solely at the discretion of the judge? And then a second questioner asks, I think a related question, which is, can attorneys opt out of in-person appearances and continue appearing virtually? Would a medical exemption be required for this?
Let me see if I can take another crack at this. After the first appearance in the resolution part, further appearances in a two-attorney case are presumptively virtual. Presumptively virtual. And by presumptively virtual, I mean that they're virtual unless the parties or the lawyers or somebody thinks there's a particular reason why there's a need for an in-person appearance. Somebody might say, I think in this particular instance, in the particular issues that are going on, judge, that an in-person appearance would be useful, and the judge can say, okay, let's do that. The first appearance in the resolution part is presumptively in person. And whether a judge permits that one to go virtual would depend upon the judge hearing from the parties or the lawyers and deciding that that was okay. We have asked judges to look at their part rules in light of this process and to consider whether they need to amend their part rules to say how they're going to handle things like that.
Are pending HRA applications, I assume that's one-shots, being considered the same as ERAP to hold the case until a decision on either application is made to prevent an eviction?
Not in the same way, because an ERAP application under a specific statute, the filing of an ERAP application stays the case unless it's a nuisance holdover or that owner-occupied small building thing. So that is absolute. The case just comes off the calendar. The HRA applications would be handled by individual judges as they did pre-COVID. If there's a pending application and there's an order to show cause seeking more time to pay, a judge can decide how to handle the case in light of that, but there isn't a specific statute that requires that case be stayed.
This is back to the ventilation system. Would the court share the investigation into the ventilation system with the public, or has it been shared already?
It has not, and it will not. there were requests very early on for public sharing of that information that were rejected at a much higher level in the court system than me.
So here's a question. Will tenants who have been served eviction notices be allowed to remain in their homes once the landlord receives the rent relief? I assume that's if a tenant applies for ERAP and gets it, would that sort of...
If a tenant applies for ERAP, it stays the case. If the ERAP stay applies, then there's not going to be an eviction. And I should say that there's a provision in the law that says that a hardship declaration can be handed to the marshal at the door if the tenant is entitled to a hardship declaration.
Believe it or not, that's the end of the questions. And
Wow.
So if there's any that pop in.
I think that's because we're all exhausted.
Well, there is one more, I'm sorry. It's sort of going over what you've gone over already, but why does the first resolution part appearance have the presumption of being in person? What is OCA's rationale in doing that, considering the Delta variant and other health and safety concerns? Shouldn't it only be when the parties and the judge feel it is necessary?
Our rationale is this. You all know that pre-COVID, housing parts frequently had 50 or more cases a day. Our current virtual calendars can't really take in more than about 24 cases a day. We believe that we have to move by carefully considered steps to a place where we can get to some kind of new normal. Our new normal will definitely, even if we reach a point where the COVID period is closed, we're done with it, there will always be virtual appearances. So virtual appearances will always be part of our new normal in some way or other. But we believe that by combining virtual and in-person appearances, we will be able to address more cases in a sensible and controlled fashion. And the only way to find out whether that's true is to try it. We will, as we have with every step we've taken, we will carefully monitor how this stuff is going. We will move up or down in terms of the number of cases put on, in terms of the scheduling procedures and so on, depending on how things go, depending on what the circumstances are outside the courthouse and so on. But we feel that this is an appropriate time to take a step like this because if you look in the outside world, more people are returning to work in person. Students are returning to school in person. People are eating indoors in restaurants and going to baseball games. And I think that a very measured toe in the water on in-person housing court is appropriate now. So that's why we're trying it now. We don't think that our future is going to be entirely virtual all the time. And we want to see how we can integrate virtual and in-person calendars in a very small way to begin with.
Great. Thank you very much, Judge Schneider. I thank everyone for joining us today. I know not everyone is happy with either that I didn't read out your question, and usually those were for people who wanted individual advice about their cases, which isn't totally appropriate for this setting. And I would urge you to, for those of you who missed the beginning of this, is to look on our website maybe in a day, and a recording of this talk by Judge Schneider and the Q&A will be on our website, so folks can look over the questions that maybe that they missed. And once again, Judge Schneider, thank you so much for joining us. And I'm gonna say we'll probably have to do this again in some time.
I'm sure.
So as things change again, but thank you very much. And thanks to everyone for joining today.
Thank you all.